This is the Study for the Bar in Your Car podcast.
We're your hosts, Maud and Claude.
Today, we are diving deep into a topic that is, well, absolutely fundamental to the legal system. Evidence.
And we really want to give a huge thank you to Angela. She's a real-life human being, an LLM law student, and she generously provided her incredibly detailed notes that really form the basis of this deep dive.
Yeah, Angela definitely knows her stuff.
Yeah.
She used to be a judicial law clerk, so she dealt with evidence issues constantly.
All the time. Angela couldn't be here today, so she asked us to fill in for her normal introduction.
But don't you worry, Angela will absolutely be back.
Definitely. And if you need to contact her for the podcast, you can just email her at podcast@studyforthebarinyourcar.com.
And, speaking of Angela's expertise, she also works as a freelance law clerk. So if you happen to be an attorney, or maybe you know one who needs some ad hoc assistance, things like motions, complaints, writs, answers, briefs, that sort of thing.
Right, all that good stuff. You can email her at hello@legalwriterandlawclerk.com.
Okay, so using Angela's comprehensive notes, our mission today is to really unpack the core concepts, the rules that dictate what information actually makes it into court.
Yeah, we're going to cover the whole spectrum. How evidence is presented, what makes something relevant, and importantly, why some relevant things still get excluded.
Right, and privileges, that's a big one. How to handle writings and recordings.
And, oh yeah, the notoriously complex world of hearsay. We'll definitely get into that.
Think of this as your shortcut to understanding the fundamental rules that shape how facts get determined in the legal arena.
Okay, let's kick things off right at the beginning.
Yeah.
The presentation of evidence in court. How does that process actually work under the rules?
Well, generally, the Federal Rules of Evidence, the FRE, they apply in most U.S. court proceedings, but, not everywhere, right? There are exceptions.
Exactly. They don't strictly apply when a judge is deciding those preliminary questions of fact that determine admissibility.
Like whether a witness is competent, or if a document is real.
Precisely. For those decisions, the judge isn't bound by the rules of evidence, except for privilege. They can look at almost anything.
So wait, the judge can use info the jury won't see just to decide if other info gets in?
That's the idea. It gives the judge flexibility in that gatekeeping role. So, for example, a court might consider otherwise inadmissible hearsay to decide if, say, a photograph is admissible.
Okay, so the judge decides admissibility, often away from the jury.
Right, especially for sensitive stuff like confessions or, other hearsay issues. The jury's job is totally different.
They decide credibility, how much weight to give the evidence.
Exactly. Once the judge lets it in, the jury decides if they believe the witness and how important the evidence is.
So if you think a rule is being broken during trial, you have to object, right then and there.
Absolutely.
Yeah.
To save it for appeal, the objection has to be timely, and you need to state a specific ground, objection hearsay or objection leading.
A general objection isn't usually enough.
Might be if the reason is super obvious, but specific is always, always better. Don't risk it.
And what if the judge makes a mistake, admits something they shouldn't have?
That's what appeals are for. The appellate court decides if the error was harmless, meaning it didn't really affect the outcome, maybe there's lots of other evidence, or if it was prejudicial or reversible, meaning it did affect a substantial right, likely swayed the outcome. That could lead to a new trial.
Okay, let's talk about witnesses, the people actually testifying. What are the basics for someone to even be allowed to testify?
It's pretty straightforward under the FRE. They need personal knowledge. They have to have actually seen or heard what they're talking about, and they have to take an oath or affirmation to tell the truth.
Can they just say they have personal knowledge?
Yeah, usually their own testimony is enough to establish that.
What about interpreters?
They have to be qualified and also take an oath for accurate translation.
And the judge can't testify, right? In their own trial?
Definitely not. Rule 605 forbids that.
Okay, opinions. Lay witnesses, regular people, they can give opinions sometimes.
Yes, but it's limited. Their opinion has to be, 1, rationally based on their own perception, and 2, helpful to understanding their testimony or figuring out a fact.
And not based on specialized knowledge?
Crucially, no. That's reserved for experts. Lay opinion is things like, he seemed angry, the car was going fast, identifying a voice they know, saying someone seemed drunk.
What about identifying handwriting?
Yeah, or the value of their own property or services, things based on common experience and their own perception. A cashier identifying handwriting on a check they saw signed, that's a good example.
Can a lay witness give an opinion on the, ultimate issue?
Yeah.
Was the defendant negligent?
Generally, no, not using those legal terms, but they can give opinions on facts that lead to that ultimate issue, like he seemed intoxicated, if it meets the perception and helpfulness tests.
Okay, that makes sense. So experts are for the stuff beyond everyday understanding.
Right. Expert testimony is admissible if the subject matter needs specialized knowledge to understand it. Their opinion has to be based on sufficient facts or data.
And reliable methods.
Exactly. Reliable principles and methods applied reliably to the facts of the case.
How does the judge figure out if the expert's science or method is actually reliable? Isn't that the Daubert thing?
Yes, that's the judge's gatekeeper role under Daubert. They use factors often remembered by the mnemonic TREP.
Trap.
Testing, has the theory been tested? Rate of error, what's the known error rate? Acceptance, is it generally accepted in the field? And peer review publication.
So the judge vets the science before the jury hears it.
Essentially, yes, by a preponderance of the evidence standard for admissibility.
Can experts give an opinion on the ultimate issue?
Generally, yes. But, big exception in criminal cases, Rule 704B says an expert cannot state an opinion about whether the criminal defendant had the specific mental state required for the crime if that mental state is an element of the crime.
So no, he intended to kill him.
Right. But interestingly, a lay witness could potentially give an opinion on the defendant's mental state. He seemed really angry and determined, if it meets the lay opinion rules.
And experts can't just say that other witness is lying.
Correct. Assessing witness credibility is generally for the jury. Experts usually can't opine directly on that.
Okay, shifting back to the courtroom flow. The judge controls how the evidence comes in.
Big time. Yeah. The court has broad discretion over the order of witnesses, how questions are asked, all aimed at finding the truth efficiently and protecting witnesses.
What if a witness is on the stand and just blanks, forgets something they clearly knew before?
That's where refreshing recollection comes in. They can use a writing or really any object to jog their memory while testifying.
Does the other side get to see that document?
Yes, the adverse party has the right to inspect it, cross-examine the witness about it, and even introduce relevant portions into evidence.
What if they looked at it before testifying?
Then the adverse party only gets those rights if the court decides it's necessary in the interest of justice.
Now, this is different from past recollection recorded, right?
Yeah, totally different. Refreshing means the witness now remembers and testifies from their refreshed memory. Past recollection recorded, or PRR, is a hearsay exception.
Okay, explain PRR again.
PRR applies when the witness still can't remember fully, even after trying to refresh. If they made or adopted a record about the matter when it was fresh in their memory, and the record accurately reflects their knowledge then, the record itself can be read into evidence.
So the record becomes the evidence because the witness can't testify from memory.
Exactly. With refreshing, the testimony is the evidence. With PRR, the record is read in as substantive proof. Big distinction.
Got it. What about keeping witnesses out of the courtroom? Sequestration.
Rule 615. The court must exclude witnesses at a party's request or on its own so they don't hear each other's testimony and potentially confirm their stories.
Are there exceptions? Can anyone stay?
Yes. A natural person who is a party can stay. A designated representative of a corporate or entity party, like the lead investigating officer for the prosecution, and someone whose presence is essential to presenting a party's case, like an expert needed to advise counsel, or maybe a summary witness.
Okay, moving beyond testimony to actual things. Real evidence, like the gun, or demonstrative evidence, like a chart.
Right. Those also need to be relevant, obviously, and they must be authenticated.
Authentication just means proving it is what you claim it is.
Basically, yeah. You need to offer enough proof that a reasonable juror could find the item is authentic. It's not a super high bar for admissibility.
How do you do that?
Lots of ways. Witness testimony, someone recognizes it. If it's unique, like a gun with a specific scratch. For things that aren't unique, like a bag of white powder.
Chain of custody.
Exactly. You need to show it was handled properly from the moment it was seized until court, proving it's the same item and wasn't tampered with.
What about photos or videos?
Someone familiar with the scene or person depicted just needs to testify that it's a fair and accurate representation. Doesn't have to be the photographer.
How do you authenticate handwriting? Or a voice?
Handwriting. Lay opinion, if familiar before litigation, expert comparison or jury comparison, voice ID. Anyone who has heard the voice, even just once, even for litigation purposes, can give an opinion.
Phone calls.
Authenticate by voice recognition, the speaker knew unique facts, calling a known number and getting the person, or calling a business and discussing relevant business.
Are some things just assumed to be authentic?
Yes, self-authentication under Rule 902. Things like certified copies of public records, official publications, newspapers, trade inscriptions, they don't need separate testimony to prove they are what they appear to be, though the opponent can still challenge genuineness.
What about really old documents?
The ancient document rule for authentication. 20+ years old, condition okay, found where you'd expect. Presumed authentic. But remember, the related hearsay exception only applies if prepared before 1998.
And the reply letter doctrine.
That helps authenticate a letter by showing it was sent in reply to an earlier communication. The context makes it likely it's from the purported author.
Okay, let's quickly touch on presumptions.
Presumptions are basically legal shortcuts. Proof of fact A allows the jury to infer fact B. They can be rebuttable, meaning the other side can offer evidence to disprove fact B, or sometimes conclusive. Think presumption of sanity, or that a properly mailed letter was received.
State law matters here sometimes.
In civil cases, yeah. If state law governs the claim, state law usually governs the effect of presumptions.
And in criminal cases.
Presumptions must be permissive, not mandatory. The jury may infer the presumed fact, but they don't have to. A mandatory presumption shifting the burden on an element of the crime. That's unconstitutional.
What if evidence is okay for one purpose but not another?
Limited admissibility, Rule 104B. The judge must give a limiting instruction if requested, telling the jury to only consider it for the proper purpose.
Can the judge just keep it out entirely?
Yes, under Rule 403, balancing. If the risk of the jury misusing it for the improper purpose substantially outweighs its value for the proper purpose, the judge can exclude it.
Like that accident recording example? Maybe speed is okay, but the part about cause is too prejudicial?
Could be. Which also brings up the role of completeness. Rule 106.
Remind me.
If one side introduces part of a writing or recording, the other side can immediately require introduction of other parts or other related writings recordings that fairness require be considered at the same time. Prevents misleading snippets.
And this can overcome a hearsay objection.
The rule says so, yes. It allows the necessary context in, even if it's technically hearsay, though courts sometimes debate the scope of that.
Last thing in this section. Illustrative aids. Charts. Models.
Generally, they aren't evidence themselves, just tools to help the jury understand testimony. They usually don't go back to the jury room unless parties agree or the court finds good cause. This is different from Rule 1006 summaries of voluminous records, which are evidence.
Okay, presentation covered. Now, the absolute baseline, relevancy, is the evidence even related to the case?
Right. Rule 401 sets the standard. Evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence.
Any tendency at all. Low bar.
Very low bar. Just needs to shift the needle slightly. And B, the fact must be of consequence in determining the action, meaning it matters to the outcome based on the substantive law.
And Rule 402, relevant evidence is generally admissible.
Generally, yes. Unless some other rule, statute, or the Constitution keeps it out.
But then comes Rule 403, the big balancer. Even relevant evidence can be excluded.
Yes, if its probative value, how much it actually proves the fact it's offered for, is substantially outweighed by certain dangers.
Dangers like?
Unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or just being cumulative, needlessly repetitive.
Substantially outweighed seems key. It's not just any prejudice.
Exactly. It has to be unfair prejudice, meaning it risks an emotional or improper basis for the jury's decision, not just that it hurts the other side's case. Evidence that makes the jury hate the defendant for reasons unrelated to the actual charge, for instance.
What goes into that balancing test?
How likely is it to stir up emotions? Can a limiting instruction actually work? Is there other, less prejudicial way to prove the same point? How central is the evidence?
Okay, let's hit a major relevancy battleground. Character evidence.
Ah, yes. The general rule, the propensity rule under 404A, is a big NO. You generally cannot use evidence of a person's character trait to prove they acted in conformity with that trait on a specific occasion.
So, no, he's a known liar, therefore he probably lied on the stand. Or she's careless, so she probably ran the red light.
Correct. That's using character for propensity, and it's usually barred in both civil and criminal cases. But, like many rules, there are crucial exceptions, especially in criminal cases.
Okay, like the defendant offering evidence of their own pertinent good character.
Yes. A criminal defendant can introduce reputation or opinion evidence of a character trait relevant to the crime charged, like peacefulness in an assault case, to argue they're unlikely to have done it. This is called opening the door.
And they can sometimes attack the victim's character.
In specific situations, yes. For instance, the defendant might offer reputation or opinion evidence of the victim's violent character to support a self-defense claim, suggesting the victim was the first aggressor.
If the defendant does that, what can the prosecution do?
They can rebut. If the defendant attacks the victim's character, the prosecution can offer evidence of the victim's good character for that same trait. If the defendant offers evidence of their own good character, the prosecution can offer evidence of the defendant's bad character for that same trait.
What about specific things the person did in the past? Specific instances of conduct?
Generally not admissible to prove character for propensity. However, if character is actually an essential element of the claim, charge, or defense, then specific instances are allowed.
When would that happen? It sounds rare.
It is relatively rare. Think defamation cases where truth is a defense proving the person is actually dishonest might require specific acts. Or negligent entrustment cases proving the owner knew the driver was reckless might involve prior specific acts of recklessness. Also, remember cross-examination. If the defendant calls a character witness to testify about their good reputation, the prosecutor can ask that witness on cross about specific bad acts of the defendant to test the basis of the witness's knowledge and opinion. Did you know he did X?
What about prior convictions? We use those, don't we?
Yes, but primarily for impeachment attacking witness credibility under Rule 609, not directly as propensity evidence under 404. The rules are specific.
How does 609 work again, briefly?
It depends. For a criminal defendant testifying, felony convictions come in only if probative value outweighs prejudice. For other witnesses, the standard is tougher for exclusion. Probative value must be substantially outweighed by prejudice. Crimes involving dishonesty usually come in subject to balancing, and there's a 10-year time limit rule that makes older convictions much harder to admit.
Okay, so that's for credibility. What if someone has a very specific routine? Not general character, but like always locks the door. Is that different?
Yes, that's habit under Rule 406. Evidence of a person's habit or an organization's routine practice is admissible to prove they acted in conformity with it on a particular occasion.
What's the difference between habit and character again?
Habit is specific and regular. It's a consistent response to a particular situation, like always checks the mail after work. Character is more general, like honest or careless. Habit requires frequency and specificity of the circumstances. Business routine is the organizational equivalent, showing the company always sends invoices on the 15th to prove this invoice was likely sent then.
Okay, makes sense. Now, what about other specific bad acts, Rule 404B, not for propensity, but for other reasons?
Exactly. Evidence of other crimes, wrongs, or acts is inadmissible to prove character to show action in conformity therewith. But it can be admissible for non-propensity purposes.
Such as?
The rule lists examples. Proving motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, often called amicic evidence, though the list isn't exhaustive.
So you can't use a prior drug sale to show the defendant is a drug dealer and likely made this sale?
Correct, not for that propensity inference.
But you might be able to use it if, say, the prior sale showed knowledge of how to package drugs in a specific way relevant to this case. Or maybe a unique method, modus operandi, to prove identity.
Exactly. Or to show intent in a case where the defendant claims accident or mistake, like prior similar discriminatory acts to show discriminatory intent in the current case, or prior similar property sales to prove value.
What about intrinsic evidence?
That's conduct that's inextricably intertwined with the charged crime, part of the same transaction, necessary to tell the story. Some courts see it as falling outside 404B, but it's still subject to Rule 403 balancing.
Does the prosecution have to give notice if they plan to use 404B evidence?
Yes, in criminal cases. Upon request by the defense, the prosecution must provide reasonable notice of the general nature of any such evidence they intend to use at trial. Helps prevent unfair surprise. No notice requirement in civil cases.
Okay, last couple of relevancy-based exclusions. Liability insurance.
Rule 411. Evidence that someone was or wasn't insured against liability is not admissible to prove they acted negligently or wrongfully. Policy is to encourage insurance.
Any exception?
Yes, admissible for other purposes, like proving ownership or control, if disputed, or showing witness bias, like an insurance adjuster testifying. And if someone blurts out an admission tied to insurance, don't worry, my insurance will pay, the whole statement might come in if you can't separate them.
And evidence of a victim's sexual behavior. Rule 412.
Highly restricted, especially in criminal cases involving sexual assault, generally inadmissible. Very narrow exceptions, like proving the source of semen or injury or consent between the victim and the accused.
What about in civil cases?
Still very restricted. Admissible only if its probative value substantially outweighs the danger of harm to the victim and unfair prejudice. That's a reverse 403 standard, much harder to meet. Reputation evidence only if the victim puts it in issue.
Q. Okay, beyond relevancy, there are privileges. These block info for policy reasons, right?
Exactly. They protect important relationships or societal interests. Rule 501 says federal common law generally governs privilege claims in federal court.
Unless state law applies.
Right. In civil cases, if state law provides the rule of decision for the claim or defense, like in diversity cases, then state privilege law applies. The Erie Doctrine again.
Okay, the big one. Attorney-client privilege.
Protects confidential communications made between a client and attorney for the purpose of seeking or obtaining legal advice or services. Applies inside and outside court.
What's not covered?
Things the lawyer just observes, like the client's demeanor, fee arrangements usually. The client's identity, generally, unless revealing it, would reveal the confidential communication itself.
What if two people go to a lawyer together? Joint clients.
The communications about their common interest are privileged against the outside world. But if those two clients later sue each other, the privilege doesn't apply between them regarding those earlier shared communications.
How do you lose the privilege? Waiver.
The client holds the privilege so the client can waive it.
What if it's waived by accident?
Yeah.
Like sending the wrong email attachment.
Rule 502B addresses inadvertent disclosure. It's not a waiver if the holder took reasonable steps to prevent disclosure and took prompt, reasonable steps to rectify the error once discovered. You gotta act fast.
And intentionally revealing something privileged.
That can waive the privilege not just for what was disclosed, but potentially for the entire subject matter, especially if it was disclosed to an adversary. Rule 502 tries to limit the scope of subject matter waivers, particularly for inadvertent disclosures.
This is different from the ethical duty of confidentiality, right?
Yes. Privilege is an evidentiary rule protecting communications. The ethical duty is broader, covering almost all information relating to the representation, regardless of source.
Is there a crime fraud exception?
Absolutely. Communications made to further a crime or fraud are not privileged.
How is work product different?
Attorney-client protects the communication itself. Work product protects materials prepared in anticipation of litigation or for trial. Think lawyer's notes, mental impressions, strategy memos. It protects the lawyer's thought process and the adversarial system. Can overlap, like a client statement taken specifically for litigation.
Okay, on to marital privileges. There are two.
Correct. Spousal immunity and confidential marital communications. Very different.
Spousal immunity.
Applies only in federal criminal cases. Protects a person from being forced to testify against their current spouse. The witness spouse holds the privilege. They can choose to testify. The defendant's spouse can't stop them. Only applies during a valid marriage.
So if they divorce, immunity is gone.
For spousal immunity, yes.
And confidential marital communications.
This protects communications made in confidence between spouses during the marriage. Applies in both civil and criminal cases. Both spouses hold this privilege. It survives divorce and death. One spouse can block the other from revealing a confidential communication made during the marriage.
So an ex-spouse can't testify about what their former spouse told them in confidence while married.
Not if the other spouse objects, no. Protects the communication itself.
Crime fraud exception here, too.
Yes. Communications furthering crime or fraud aren't protected.
What about settlement talks? Rule 408.
Right. Offers to compromise a disputed claim and statements made during those negotiations are inadmissible to prove liability or the amount. Policy is to encourage settlements.
But they can come in for other reasons.
Yes, like showing bias, proving delay, obstructing an investigation.
Any exception for admissions made during settlement talks?
Generally inadmissible, but admissions made during settlement talks with a public regulatory agency might be admissible in a later criminal case. That's a specific carve-out.
How does this differ from offers to pay medical bills? Rule 409.
Rule 409 excludes offers to pay medical or similar expenses to prove liability for the injury. Key difference. 409 applies even if the claim wasn't disputed yet.
And what about admissions made with the offer to pay medical bills? Like, I'm sorry I ran the light, let me pay your hospital bill.
Huge distinction. Rule 409 only excludes the offer to pay the bills. The accompanying statement of fault, I'm sorry I ran the light, is not excluded by Rule 409 and is likely admissible as an opposing party statement.
Got it. That's tricky. Any governmental privileges?
Yes, things like state secrets, official information. Also, the informer's privilege protecting the identity of confidential informants unless the government waives it by disclosure.
Okay, shifting gears to physical evidence again, but specifically writings, recordings, and photographs, WRPs. The best evidence rule, Rule 1002. What's the core idea?
It's really the original writing rule. To prove the content of a WRP, you generally need the original.
When does proving the content actually matter?
When the document itself has legal effect, a contract, a will, a deed, or when a witness's knowledge comes only from reading the document, like testifying about X-ray contents without the X-ray. Basically, whenever what the document says is the point. If you're proving something else about the document, like it exists, or a fact the document just happens to record, like your age, the BER often doesn't apply. You don't need your birth certificate to testify how old you are.
Can copies be used? Duplicates.
Yes, Rule 1003 says duplicates, like photocopies, digital copies, are admissible just like originals, unless there's a real question about the original's authenticity, or it would be unfair to use the duplicate.
When is the original not required at all?
Rule 1004 lists exceptions. If originals are lost or destroyed, not in bad faith by the proponent. If you can't get the original via subpoena, if the opponent has the original, knows you need it, and won't produce it, or if the WRP deals with a collateral, unimportant issue.
Public records. You need the originals for those.
No, Rule 1005 allows certified copies or copies compared by a witness, easier to deal with official documents.
What if you have mountains of documents? Too much for court.
Rule 1006 allows summaries, charts, or calculations, but the underlying voluminous WRPs must be made available to the other side, and the summary must be accurate. Unlike illustrative aids, these summaries are evidence.
Authentication still applies to all these WRPs.
Absolutely. Rule 901. Need proof they are what they claim to be. Witness testimony, distinctive characteristics, maybe self-authentication for certain types.
And the rule of completeness we discussed. Still relevant here.
Very much so. Rule 106. If one side offers part of a document or recording, the other side can require other relevant parts immediately to avoid a misleading impression.
All right. Deep breath. The Mount Everest of evidence. Hearsay.
Okay, let's do it. Rule 801C definition is key. Hearsay is 1, an out-of-court statement, 2, offered in evidence, 3, to prove the truth of the matter asserted in the statement. All three parts must be present.
Statement includes actions.
Oral or written assertions, yes. And nonverbal conduct if the person intended it as an assertion, like nodding or pointing.
Out of court means not on the witness stand right now.
Right. Made outside the current trial or hearing.
And offered for the truth of the matter, asserted. That's the tricky one.
That's the core. Are you asking the jury to believe what the statement says is true? If yes, it's hearsay, unless an exclusion or exception applies. If no, it's not hearsay.
So what are examples of offering a statement not for its truth?
Lots. Verbal acts, words that have legal significance themselves, like, I accept your offer in a contract case, or defamatory words. The statement is the legal event, also showing the effect on the listener. Offering a warning statement, not to prove the danger was real, but to show the listener was put on notice, or showing why someone acted a certain way based on what they were told. Statements offered just to impeach a witness's credibility by showing inconsistency, unless it was a prior sworn inconsistent statement, which is non-hearsay offered for truth. And things not said by humans' machine readouts, dog alerts, aren't statements under the rule, so not hearsay.
Okay, so those are not hearsay because they aren't offered for the truth. Are there statements that are offered for the truth but are defined as non-hearsay?
Yes. Rule 801 side lists crucial exclusions from the hearsay definition. These are technically not hearsay by rule. Two big categories.
First,
certain prior statements by a witness who is now testifying and subject to cross-examination about the prior statement. Includes prior inconsistent statements made under oath at a prior proceeding admissible for truth. Prior consistent statements offered to rebut a claim of recent fabrication made before the motive to fabricate arose, and prior statements of identification.
Okay, so if the speaker's on the stand now, some of their earlier statements get special treatment. Second category of exclusions.
Statements made by or attributable to an opposing party, offered against that party. Rule 801-2. These are often called admissions, but the rule doesn't use that term anymore.
What counts as an opposing party's statement?
The party's own statement, obviously. An adoptive statement, one they indicated they agreed with, maybe by silence when denial was expected. A statement by someone they authorized to speak. Also, a vicarious statement by their agent or employee about something within the scope of employment made during the employment relationship.
And co-conspirator statements.
Yes, statements by a co-conspirator made during and in furtherance of the conspiracy are admissible against other members of the conspiracy.
Wow, so all those are just not hearsay, period, even though offered for truth.
Correct. Big difference. Now, for statements that are hearsay but might still get in, we need an exception.
Okay. Exceptions. 2 types based on whether the declarant needs to be unavailable.
Right. Rule 803 exceptions apply regardless of whether the declarant is available. Rule 804 exceptions apply only if the declarant is unavailable.
Let's hit the rule. 803 highlights first, availability doesn't matter.
Present sense impression, PSI. Describing an event while or immediately after perceiving it. Spontaneity is key. Excited utterance. Statement about a startling event made while under the stress of excitement caused by it. Focus on the stress. Then, existing mental, emotional, or physical condition, state of mind. Statement about current state of mind, intent, plan, motive, or physical feeling. Pain. My back hurts. I plan to go to Chicago. Not statements about past feelings or beliefs about memory. Statements for medical diagnosis or treatment. Describing medical history, symptoms, cause, if reasonably pertinent to diagnosis or treatment. Rationale. People are usually truthful when seeking medical help. Can include cause and relevant to treatment, ladder hit my head, but usually not fault, he ran the red light. Recorded recollection, PRR, we discussed this. Witness can't recall, but made adopted accurate record when memory was fresh. Record read in. Business records. Records of regularly conducted activity made near the time by someone with knowledge duty, regular practice to make such records trustworthy. Foundation needed. Includes opinions, diagnoses, if routine. Public records. Records of public office activities, matters observed under duty, but not police observations in criminal cases against defendant, or factual findings from investigations, civil cases, or against of in criminal. Trustworthiness can be challenged.
Okay, those apply even if the speaker could testify. Now, Rule 804 declarant must be unavailable. What counts as unavailable?
Privilege claim upheld. Refuses court order to testify. Testifies to lack of memory, dead or too ill, or absent, and proponent couldn't procure attendance via reasonable means.
If unavailable, what exceptions might apply?
Former testimony. Given under oath in prior proceeding where the party it's now offered against, or predecessor in civil case, had opportunity and similar motive to cross-examine. Dying declaration. Statement made under belief of imminent death concerning the cause or circumstances of the believed impending death. Applies in homicide cases and all civil cases. Declarant must have personal knowledge. Statement against interest. Statement so contrary to declarant's pecuniary, proprietary, or penal interest that a reasonable person wouldn't have said it unless true. If offered to exculpate accused in criminal case, needs corroboration. Covers only the self-inculpatory parts. Statement of personal family history, about declarant's own or related person's lineage, marriage, birth, death, etc. Forfeiture by wrongdoing. Statement offered against a party who intentionally and wrongfully caused the declarant's unavailability to testify. Basically, you can't benefit from silencing a witness.
Okay, what if there's hearsay within hearsay? Like a business record contains a quote from a customer.
Multiple hearsay or hearsay within hearsay. Rule 805. Each level needs its own independent basis for admission, an exclusion, or an exception. The business record itself might fit 803.6, but the customer's statement within it is still hearsay and needs its own exception, like maybe PSI or an opposing party statement, to come in for its truth.
Last piece, the confrontation clause. How does that layer on top in criminal cases?
The Sixth Amendment guarantees a criminal defendant the right to confront witnesses against them. This limits the use of out-of-court testimonial statements by unavailable declarants.
What's testimonial?
Generally, statements made with the primary purpose of creating an out-of-court substitute for trial testimony, like statements to police investigating a past crime. Statements made during an ongoing emergency to get help are usually non-testimonial.
So even if a statement fits a hearsay exception, if it's testimonial from an unavailable witness, and the defendant didn't have a prior chance to cross-examine,
it's likely barred by the confrontation clause. It's an additional hurdle for the prosecution in criminal cases for certain types of hearsay. So, That's our deep dive. We've really covered a lot of ground, from presenting evidence, figuring out relevance and Rule 403 exclusions, digging into privileges, handling writings and recordings with the best evidence rule, and navigating the maze of hearsay.
Yeah, these rules are absolutely the gatekeepers. They fundamentally shape what information a judge or jury gets to hear, which, directly impacts case outcomes based on what's considered reliable and fair.
And we absolutely have to thank Angela again for sharing her fantastic evidence notes. They were incredibly helpful for putting this together.
Definitely. And just a reminder, if you want to reach out to Angela about the podcast, the email is podcast@studyforthebarinyourcar.com.
Right. And don't forget, she's also a freelance law clerk. So if you're an attorney or you know one who needs help with research, motions, briefs, anything like that,
you can email her at hello@legalwriterandlawclerk.com.
So maybe a final thought to leave you with. Think about all the information swirling around you every day. Conversations, emails, news, social media. How much of that would actually survive these strict evidence rules and make it into a courtroom?
Yeah. And what does that tell us about how the legal system tries to nail down something as slippery as truth? Something to chew on.
Hey, this is Angela. Thanks for tuning in for the podcast. I hope you enjoyed that overview of evidence. And yeah, we will get into it with the next topic. All right? See you on the next podcast. Bye-bye.